From TeachIllinois.com, this is The Teacher's Classroom, the podcast that explores current issues and topics in education and how they relate to teaching and students. Here is your host, Matt Weld.
Hello and welcome to episode 6 of the Teacher's Classroom podcast, which is part of the Teach Illinois system of professional development. If this is your first time joining us, I hope you'll go back to episode 5, where I first introduced attorney Chad Watkins. He is a former special education teacher turned attorney, and we are so glad to have him with us. In our previous episode, we were talking about bullying and how it affects teachers in the classroom, and specifically covering important topics such as the protected classes of students where you really have to pay attention to whether or not they're being bullied. We also then kind of finished up our conversation with some advice from Chad from the teacher's perspective, from his teacher's background, where he said that, run your classroom, deal with bullying in your own personality. That's how it's going to be most effective. And then he switched hats and put on his attorney's hat and said, the best thing that you can do is to document. So document everything in your classroom. As we move into episode 6, we kind of shift the conversation over to the district or school administrator side. So we're going to talk about the Constitution and how students' constitutional rights come into play when it comes to questioning them, when it comes to searching them. So thank you for joining us. I hope that you find something useful from this podcast. And here we go in progress with Chad Watkins. All right, now let's take this up to, out of the classroom lens now and to the
Sure.
school-wide lens. And
Okay.
So I'd like to talk next about what the responsibilities are of school administrators, particularly building principals. I guess this could then spill over into the superintendents. Should the issues be big enough that they're taken there, especially if it becomes legal, then your superintendent absolutely needs to be contacted.
Yeah.
Right.
That's what we get contacted.
Okay. So I guess we'll start with the middleman here, the building principals, and what their responsibilities are after it's been through the teachers, which we've just talked about with documentation and talking to parents and all that kind of stuff.
Sure. So let me talk a little bit about how a bullying issue would come from the teachers to the administrators and when that would happen. So, the teacher makes the observation that this is severe, this is pervasive, this falls within the definition of bullying. Then at that point, it's probably a good idea to bring it to the administrator's attention. If there's cases of a serious threat involving violence, then I think that should be brought to the administrator's attention. If there's suspicions of weapons, or this is a little bit outside the bullying context, but if there's suspicions of drugs and there needs to be a search or there needs to be investigation, I think that's usually best conducted by the administration. So once it is in the administrator's hands and they have reason to believe that there is some serious bullying going on, then it's time to really begin the investigation piece of this.
All right. And that always scared me as an administrator. Do I have the right to do this? Am I infringing on the student's right? So, because I know there's constitutional rights. There's First Amendment and Fourth Amendment that.
Yeah. Oh, of course. All of the things that we talked about for teachers are still in play in determining, is this bullying? I mean, maybe a teacher perceives something that's bullying that the administration does not believe it's bullying. Those things happen. So you're going to have to evaluate all the things we talked about and so much more when you're doing this investigation. So when the bullying issue is brought to you, the first step is really to gather information from multiple sources. If you heard it from a parent, make sure that you're talking to the teachers who are present for this. If you heard it from a teacher, it's probably a good idea to talk to the students, talk to the parent, get a full understanding of what happened. Who, what, when, where, and why. And then you're asking yourself those questions that we discussed before. Is it pervasive? Is it severe? Or is this a one-off incident? And also you're considering whether there's students involved in a protected class that are involved. Age, race, gender, etc. Now, the first issue is First Amendment concerns. And students do have freedom of speech rights. They're not exactly the same as adults, but in school and out of school, students do have freedom of speech. We've basically seen 4 big cases by the Supreme Court that have looked at this question of what are the parameters of the students' rights. There's the famous one that I'm sure most of the listeners have heard of before is Tinker v. Des Moines. In that case from the 1970s, students were protesting the Vietnam War, and they wore a black armband to school. And the court determined that the district could not take action unless their speech materially and substantially interfered with the requirements of the operation of the school. So that provided initially a more expansive view of students' right to freedom of speech, but that right has been limited by later decisions. That doesn't include vulgar or offensive speech. That doesn't include speech that promotes illegal drug use. And if it's something that relates to the schools, something that bears the school logo, then the district could also take action there. So moving to bullying, if something's causing a substantial disruption, or it's something that's clearly vulgar or offensive, it's within the school's rights to take action on that speech. Where the issue comes is when the administration is faced with some kind of speech, some kind of bullying that took place off campus. Like I said, for the teachers, the administration doesn't have the job either to go out there scouring students' social media profiles to see what's being said. But when something that was said outside of school or in the social media context, and it causes a substantial disruption in the school environment, then the school can take action. Now, what is a substantial disruption? That's the big question the schools face. When is it time for me to act on this, even though the speech took place away from campus or a school event? When you see something related to possible violence, when there's causing an upsurge in truancy or disruption of class time, is there a true threat that's going to pose a safety risk to your school? That's the kind of stuff where schools can step in and do something about it.
Yeah. Okay.
Yeah.
So once again, it's the substantial, pervasive, and severe.
Exactly. Now, looking at a couple of different cases that have looked at these questions, there's one case where several students missed days of school because of ongoing harassment on a social media site away from campus. In that case, the court held that the district could take action and discipline those students who harassed the students. But in another case, when an administrator was actually being made fun of by a student and it was shared with a small number of students, they determined that it wasn't a substantial disruption. And in another case, when one student just had to miss one class because she was upset over the bullying outside of school, it was determined that that was not a substantial disruption and the school couldn't take action.
So in the first one, it was
Sure.
decided that the school could take action because students missed several days. So that's the truancy you were talking about.
Yes, several days of school was key there in the court's decision. Whereas when one period of one day a student was absent for, that was not a substantial disruption.
Okay. And then the second one you're talking about, when the administrator, something was said against an administrator, but it was only shared with a small group of kids.
Yeah, it was shared with about 20 students, and they were still going to class. The biggest issue that the court found was rescheduling guidance counselor appointments, and they found that was not a substantial disruption. So there has not been a ton of case law, particularly in Illinois, defining what would be a substantial disruption or not for out-of-school statements. But again, we're looking at class time, and definitely if there's violence involved, the district is within its rights to take action.
All right. Okay. Let's see. I had another scenario for you here.
Sure.
Except I need to find it first.
No problem.
Okay. So here's another scenario for you.
Sure.
Got two 11th grade students. They're both girls. Not that that necessarily means anything. But one sends a text message to another from home after school commenting on how stupid Terry is for the wrong answer she gave in class. Terry's mother contacts you the next morning. Okay, you're the administrator. Terry's mother contacts you the next morning, informs you of the text message, and demands that the school takes immediate action. How do you handle that?
Well, clearly, we have a very concerned parent about this issue that happened. And of course, when a parent comes in with a complaint, you listen, you're respectful, you hear it, and then you kind of go back through your investigative steps. Where did it take place? It took place away from school. Was it an isolated incident? Or was it substantial, pervasive? Would it even fall in the definition of bullying? Is this something that has spilled over into the school? Has it caused much of a disruption in school at all? Is the student coming in? Is she doing okay in the classes? Is she still in the same classes as the other student? And you make that judgment call based on all those facts. If it was just an isolated text away from school and you haven't noticed anything different between the students at school, well, then that's probably not something that the district can take action on because it hasn't caused a substantial disruption. However, if through your investigation you learn that this is an ongoing thing and it happens in the classroom and this student is repeatedly missing class or upset and can't participate, well then the whole perspective on what happened could fall within the bullying definition. But just one single text away from school is probably not something the district would do anything about.
So on that phone call, I would probably just say to the mom, let me look into this and I'll call you back.
Mm-hmm. And you look into it and you see what is the nexus to the school. How is this impacting the school?
Right.
And if you answer that it's not really making a difference, well, then there's not a whole lot the school can do.
Okay. All right. So here's another one. What if you get an anonymous tip on a Monday that Tom, who's an 8th grade student, sent Juan, a 7th grade student, a threatening text message over the weekend that suggested the use of a gun?
Well, when you see anything with serious violence or the use of a weapon, you should always keep in mind that your number one priority is school safety. And again, when you have information like that, it's important that you take proactive steps to protect your school. So I think you immediately talk to those students. You get an understanding of whether this threat was a joke, whether it related to the school, what the students understood. You talk to the parents, you talk to the teachers. I think whereas in the last example, where it was just a single text message away from school, this is very different. This is going to be different because the possibility of violence and the impact on your whole school community. So I think in this case, you're definitely acting more proactively.
All right. And it would probably involve searching something.
Yes.
Okay.
If you have if you have reasonable suspicion that there could be a gun on your campus, absolutely.
Okay. So can you talk a little bit about searching now? And
sure.
On high school parking lots, it would involve cars on the school's parking lot.
Mm-hmm.
Lockers.
We move from Oh yeah, absolutely. So we move from the First Amendment. Now we're going on to the Fourth Amendment of the Constitution.